So for now, and indeed the legal position is, because Telstra is still good law, and all the High Court was saying were something by the way, Telstra's decision in the full federal court is still authority for the proposition, yes, there is intellectual property in water data. So I think it'd be prudent and appropriate for the time being to consider that there are intellectual property rights in water data. And from a dot point at the top, that's a question necessarily for the named persons providing that data to determine. The Bureau has got no right to license someone else's data. It's a fundamental tenet of copyright law unless that intellectual property right has been assigned to them. And clearly under the Act it hasn't been. Named parties are also going to be met with the interesting position that their water data will be published. So to meet the policy of the Water Act, we looked at a variety of different licensing systems and looked at how the Bureau might be publishing this information over the web, as most stuff is these days. And tried to look at what sort of Web 2.0 license would be appropriate for this. And it wasn't a foregone conclusion, even though I work in the Government Information Licensing Framework, which is fundamentally a Creative Commons license-based system. It wasn't the only license we looked at, but it turned out to be the better one. And I'll explain what that means in a moment. There are 6 licenses in the Creative Commons suite. Each of them have varying degrees of restriction, from virtually nothing to high. We wrote a report for the Bureau and the executive considered it and they endorsed it unamended. The position that they took was that the least restrictive of the Creative Commons licenses is the most appropriate license that it would endorse for named parties to use because it met with the policy of the Water Act. The policy of the Water Act, almost a no-brainer. Unless you know how much water is out there and who's got what, where and when, it's pretty difficult to manage it. And the best way to manage information is to make it available rather than sticking in a drawer. Because information in a drawer is of no use to anyone. So the license endorsed was the Creative Commons Attribution License. It's available on the website. You can check out the report. I've been around the country once or twice talking about this to a variety of government organisations who are also looking at these sorts of things. What does it look like? Well, that's what it looks like. If you were going to put that on a website or on a printed document, that little logo there is the least restrictive of the Creative Commons licenses, the one that the Bureau has endorsed, the Creative Commons Attribution Licence. You can see its attribution means by, it's by me. It's attributing the person who has supplied the information. So what it implies is that you can do anything with the information as long as you attribute me as the source. And you can't attribute me in a way that implies that there's some sort of relationship. You're simply attributing me as the source. The little link underneath that is for example, if you printed the document out, you wouldn't have a live link under the image as you would on the internet. And so you could easily type that into your URL bar in the browser and see what the license permissions were. And because it's the attribution license, we like to tell everyone that we like to be attributed as X. And in this case, for the State of Queensland, Department of Environment and Resource Management. Not Queensland Government, not DERM, but the full legal name of the department. So if you go and reuse the information in some way, shape or form, there's a requirement under the licence that you must attribute the source. Otherwise you can mash it up, manipulate it, do whatever you need to do, put it into a report or otherwise. So if you click on the logo, this takes you to the human readable deed. And one of the other features of the Creative Commons suite is that it's available in a variety of different languages. Multicultural society, very important to be able to impart terms and conditions in different languages. So this is in English, of course, but you can see you're free to share, copy, distribute or transmit the work or to remix it, provided that you attribute, but not in a way that suggests that they endorse you or the use of the work. Down the bottom, with the understanding that, that's the part of this licence that makes it compatible with Australian copyright. The part down the bottom talking about your other rights are conferred upon you by statute under the Copyright Act. I can always go and take some information from somebody else without asking permission and use it for private study. That's never been illegal. It's never been in breach of the Copyright Act. I can take some information and copy it and use it in court proceedings. That's also another exemption under the Copyright Act. There's a variety of different exemptions that are available to every person in this country to use copyright material without recourse or permission back to the owner. But if it's anything above that, the way that copyright is imparted is by license. So we're giving you an excuse that would otherwise be a breach. Now, if you're an insomniac or a lawyer or both, and you want to know what the fine legal code is, the fine print, that's the fine print. And so there are certain benefits with adopting Creative Commons. The first one is that the community understands Creative Commons. If you haven't heard of it until today, that's okay. Not all members of the community understand it, but a lot of members of the community understand it. There are about 300 or 500 million photographs licensed under Flickr under Creative Commons. Wikipedia is now entirely under Creative Commons. OpenStreetMap under Creative Commons. So it's a licensing regime that's understood by a lot of people in the world, no matter which country you come from, which language you speak. It's now time for the government to understand how Creative Commons can be used in a government scenario. And there are a lot of inroads being made into that. The Gov2O task force under Lindsay Tanner has just released a draft report recommending that Creative Commons be used by government organisations around Australia, and indeed federally, to get public sector information out there. Imagine what you could do if you had access to be able to remix and mash up the information that the government has that it uses to govern citizens. Very powerful. Even something as you would think simple as getting the locations of all the public toilets out there on one database so you could mash it up into an iPhone application. Wouldn't that be wonderful? Well, you can't do that at the moment. It's locked up behind restricted copyright, believe it or not. But some organisations like the Australian Continence Association, yes there is an organisation, who are very, very keen to invent an iPhone application so that their members can just check out where the nearest loo is. Okay, it operates in accordance with Australian copyright law. All of these licences were made compatible with Australian copyright law in 2005. They require the attribution of the rights holder as a minimum, already in use by government. In fact, my department is going to be licensing its information under the Creative Commons attribution licence to the Bureau. Those decisions have been made or are being made at the moment. And last I checked, when I was at my computer yesterday, about 18 or 19 organisations have already agreed with this regime for water. It takes the form of a plain English deed, which you've seen in numerous languages, has a low to no cost of implementation. By low to no cost for named persons under the water regulations, I mean nothing. The Bureau is writing to each of the organisations that are named in the regs, inviting them to decide whether they'd like to go for Creative Commons or not, and the stamp on the letter that they send back has already been prepaid. It also may be used as a search parameter, so if the materials are displayed on the web the right way, anyone doing an advanced Google search can search for water data under advanced, looking for Creative Commons content, because that will then tell them that they're getting information that's been licensed under CC that they can reuse, and so they can do an advanced search like that. How will this all be implemented with the Bureau? Well, firstly, we've updated the Bureau's website. There's information on there now concerning Creative Commons and the reason why the Bureau has decided to endorse CC and the attribution licence. There are some FAQs and download of the report that we produced for the Bureau as well. It's written to each of the named parties, I think 214. If a named person decides to adopt the creative, when I say named person, you understand within the context of the water regulations. A named person decides to adopt it, we'll simply say, great, how would you like to be attributed? And there's an example there for Doom. And on the second part of the letter, it says, okay, if you don't want to use Creative Commons, then we're really left with no other choice. Can you please tell us your name, contact details, phone number and email?